Um, I would like, as we need to be really quickly now, and I will like to use just 10 minutes maybe of your time, and just to speak a little bit about the financing in the mining project, but also to reflect the new regulations in Serbia, especially the draft law on geological explorations and mining, but also to reflect certain issues arising from a law on PPP and concessions, and just as Nenad mentioned, the possibilities of financing of the mining projects under this law. It's very interesting to read in the draft law on the geological explorations and mining from June 2013 that there will be the possibility to have a strategic partnership between the state and the holder of the license for the exploitation. It will be very interesting to see how this is going to be developed further on, because under the draft law it is prescribed that all the relationship between the state and the private investor would be dealt in details, and that this partnership is going to be done through the joint company, or it's in Serbian zajednička kompanija, so some kind of the SPV that is going to be engaged into the mining project. But then we have to reflect also the provisions of the PPA and concessions law, which clearly states at the beginning of the law that it's necessary wherever there is any kind of the investments of the public ownership, and in this case this is definitely the ownership of the Republic of Serbia, that we would need to apply the provisions of the law on PPP and concessions, and to do it through the SPV as prescribed in the law on PPP and concessions, which means that the state is going to be the public partner and that the private partner is going to be also the part of that SPV. Well, now when we prepared the presentation, we were thinking about what kind of the finances and financing mechanism are applicable to the PPPs in Serbia, especially talking about the law on PPPs and concessions, where it's clearly now again stipulated that now it's possible to find the financings either through the direct equity or through the debt financing, where debt financing can be debt structured financing or the project financing by international finance institutions, commercial banks, and third parties, which opens the door for a significant possibilities of financing methods for the PPPs. Then it's a question how this is going to really happen in the practice, because this is something that is a complete novelty in our regulatory system. And now we try to go through it, to go through those provisions to see whether this is possible or not. Whenever we are talking with the bankers, they are always talking about the bankability of the project, and basically what is the bankability is that term means more or less that the project would be such projects and structured in such way that the bank will like to finance it. Without the bank liking the project, this is not going to be the bankable project. And there we have lots of different issues that are related to this term bankability. And more importantly, most likely, that would be what kind of the collaterals the SPV or the private investor is ready to offer. Then what is the reputation of the SPV, of the private investor? What is the anticipated and the projected cash flow of the project? And lots of other questions that most likely the bankers would be would like to have in the project. One of the things that is listed in the law is that there is a possibility to finance the project through the concept of the project finance, which is not only for the PPAs, but this is the concept that is used for different purposes. And this means that the bank is going to finance the project through the long-term debt, through the loan, it's very important that the loan is going to be repaid through the cash flow generated in the project. The risk, once taken by the lenders, is going to stay there, and before entering into the project, the lenders should basically anticipate the risks and see how to mitigate those risks in the project. Then definitely we will have there, in addition to the lenders, we will have the private partner, and in this case, when we are talking about the PPPs, we will have also the public partner. And now, if we are talking about Serbia, local experiences are not so great in the mining sector, but we have experienced lots of project finance in some different fields, especially in the construction and especially in the commercial construction sector here in Belgrade in particular. Now, the loan PPP and the concession provides the possibility for a project finance. But then, when we are talking about the SPV, that is a main project company in the mining sector, then we need to talk about different elements of that relationship between the SPV and the lenders, and especially between the partners in the SPV and the lenders. In the normal practices, the lenders will take the lead, provide financing to the project, and the project company would need to provide all necessary covenants, representation, warranties, collaterals, projected cash flows, etc., etc. And this is in a normal course of business. But in the PPP, and especially in the SPV in the PPP, we will have the states or the state bodies or the municipalities as the public partners in the SPV. Which means, in particular, when we are talking about giving the collaterals to the lenders, that this is going to create lots of interesting solutions. And that why? Because in order for the SPV that's most likely going to use a public ownership, i.e. state ownership, that the state will be required to give its approval to each and every collateral that is going to be given over the state ownership. In theory and in the law, this is definitely it's possible, but how this is going really to work in the practice, we haven't seen that so far. But from our point of view, and I think, and also from the lender's point of view, this might create may create certain questions whether this is going to be something that is going to run smoothly or not in the practice. Next thing that is very interesting for the lenders, and this is also something that is allowed now by the PPP and concessions law, is this direct agreement. And this is something that most lenders, especially the lenders like IFC or EBRD, would ask in a project finance, which means that they would like to have the step-in rights, and if something is going wrong in the project, they will come, step in, take the lead, and complete the project. In this case, this is something that, again, in the theory looks very nice, and in the practice, whenever we have the private partners, this might be possible. But again, this is raising the questions how this is going to be possible to do it in the SPV, where we have the public partner, in this case the state, private partner, and then institutional financial institution coming into this SPV, like a private partner, like I don't know what might be a form of a participation in the SPV, where this might definitely create some additional obstacles and the problems. Local practice, especially if we are talking about the PPPs and the SPVs in the PPP, is not existing, and that's why we can't talk too much about how this is going to be in the practice. Definitely for the financiers and for the lenders, direct agreements are going to be easier way how to deal with the negative practices in the SPV and the project company, because again, once the SPV is granting the collaterals, once these collaterals are approved by the state and given to the lenders, it's again a question how this is going to be enforced, how to enforce the mortgage against the state property, how long it's going to take, what kind of additional obstacles is going to create for the lenders. In particular, it's very interesting, and Nenad also mentioned about the concession on the in the PPPs. We have now a clash of two laws. We have the law on mining and the geological exploration, where it says that strategic partnership is going to be created only with a private partner that has the license for exploitation given by that law. And on the other side, in the PPPs, we have the concession right for the exploitation. It's also prescribed that it's possible to grant the pledge of the concession rights, but how to transfer this concession, whether this concession is also this license for exploitation under the another law, or it's not, it's still a huge question, although this might be a very nice collateral for the lenders. In addition to that, we were thinking what other possibilities of financing are at the market, not maybe only in Serbia, but Europe-wide or worldwide. And definitely we have these four that could be applicable firstly to just to the private partner that has its mining projects in Serbia, or even to the PPP and the SPV in the PPP, but then different other issues would be arising, and I think that we do not have too much time to discuss those at this stage. I have international financial institutions equity. This is one of the possibilities where like EBRD or IFC would enter into the project with its own equity and acquire a certain share in the project. Private equity, different funds in the mining sector that would be ready to finance the deals. And then maybe the last ones for this presentation, mezzanine finance and commodity streaming. Mezzanine finance, it's some kind of the hybrid between the debt financing and the equity, where the lenders will provide the loan to the project company. But if something is going wrong, if the loan cannot be repaid back to the lenders will have the right to transform actually its receivables and its loan into the equity into the company. And this is something that is used strongly in some other projects, but this is something that is also applicable for the mining project. And the last that is currently very interesting in especially somewhere far away from Serbia, like Australia and the other mining countries, is the commodity streaming. Lots of companies are now being into the business of commodity streaming, and this it's being proved that is a very nice way how to finance the mining projects. Just in essence, this is the company that is basically buying upfront certain amount of the mine or whatever is going to be the product in the mining in the project, whereas the money is going to be given immediately. This is very beneficial concept for the project company because it is not required to provide collaterals. It's not necessary to provide the covenants, additional things that are generally very common into the normal project finance. And what's interesting also, the commodity forwards, this is something that is again coming into the practice here in Serbia. We have the new draft law on the commodities stock exchange, where this is going to be prescribed as one of the possibilities how to finance the deals basically through the commodity forwards. So we will just need to see and a little bit to wait and to see how the law is going to regulate this issue. This is everything for today. I think it was short. Our intention was just to say that the laws and the regulations in Serbia are good, and we have in theory really, I think, really good solutions. But then to implement this solution into the practice, we'll need a lot of additional work. But if everyone is positive and if everyone would like to cooperate, I think that this is going to be possible, and hopefully next year we will see more interesting stories about this sector. Thanks a lot, and see you.